respondent, Mrs. Howard, or most importantly, mother. This case is born out of the Sullivan County Chancery Court. It was a petition for an order of protection that was denied. Of note is there's a divorce pending and has been pending since February of 23. The mandatory associated restraining order with any divorce, according to 36-4106, is in place. The specific language states both husband and wife in this lawsuit are restrained and enjoined from harassing, threatening, assaulting, or abusing the other, and for making disparaging remarks about the other to or in the presence of the children of the parties or to either party's employer. I'd like the court to keep in mind a couple of overarching principles today and when adjudicating this case. Orders of protection are supposed to be the most pro se friendly litigation. I've referenced in my brief the trial court statement of evidence in so much as to meet the briefing requirements. I assert the correct statement of evidence for the record is my statement of evidence filed in October. The next thing I would ask the court to keep in mind is that 36-3602, which governs order protections, does not require fear. It reads, any domestic abuse victim, stalking victim, or sexual assault victim who has been subjected to, threatened with, or placed in fear of domestic abuse, stalking, or sexual assault may seek relief under this part by filing a sworn petition. The concept of fear in this case was brought forth in the appellee's response to my motion for reconsideration. On line 40, they state that I testified at trial that I was not in fear. I immediately replied and filed a response that stated I never said that. Again, fear is not required. Finally, there's some talk about some discussion about what evidence is actually on the record and whether or not I made offers of proof. Where the substance of evidence is apparent by the context, no offer of proof is required. I would also assert that in the normal course of a trial, the opposing side should object to evidence, and the trial judge should adjudicate that by either overruling or sustaining the objection. In this case, that didn't happen. The judge lodged his own objections and adjudicated them. There are 6 issues for appeal here today, Your Honors. Whether or not the record contains the correct statement of evidence and exhibits, it was properly crafted, all issues were properly resolved, it conveys a fair, accurate, and complete account of what transpired, whether the trial judge incorrectly relied on appellee's statement of evidence. Appellant asserts he is entitled to default judgment for the ex parte communication by the other side according to Tennessee Code 45304, and a new trial for the balance. Number 2 is whether the trial judge erred by failing to provide findings of fact and conclusions of law. The court has 2 options here. In Crouch v. Crouch, it can soldier on, or it can remand the case and order that the judge make findings of fact and conclusions of law. Unfortunately, the trial judge is no longer on this case, so it will require a new trial. Number 3 is whether the judge erred by denying the petition for order of protection. We'll talk about that in a bit. Number 4 is whether the trial judge erred by removing the petitioner's children during the hearing, since box 2 wasn't checked on the petition. Number 5 is whether the trial judge erred in preventing evidence prior to December of 2022. Number 6 deals with attorney's fees. There is no final order, so it's not ripe for review. Number 1, whether or not the record contains the correct statement of evidence. Appellant asserts that appellee did not submit any objections or a statement of evidence until after the 15-day window provided by this court. Further, the trial judge took no action in the 30-day window after the appellee's window closed. Therefore, according to Rule 24F, and there's very strong language in that rule from this court that says it shall deem the appellant's statement of evidence as the correct statement. In adjudicating the statement of evidence at the trial level, Appellee's counsel mailed an appearance notice to the appellant regarding a December 15th hearing. That notice was mailed on December 13th. I didn't receive it until December 16th. I received a call that Friday on December 15th from a clerk that said, "Are you coming to today's hearing?" I had no idea there was a hearing. I gathered my belongings, went down to court, and the judge moved it until December 18th. On December 18th, something very interesting happened. The notice that was mailed on December 13th called for a hearing on the statute of limitations for the appeal. A trial judge in a trial court has no authority over an appeal. At trial, they asked the judge, at the hearing, they asked the judge to backdate the dismissal order on September 7th. The judge had failed to check the dismiss box. They asked him to nunc pro tunc enter that order back to September 7th, and he did. Then they tried to apply 363601F that states I have 10 days to appeal. That's for General Sessions Court, Your Honor. This was a Chancery Court. I have 30 days to appeal. The judge replied and granted the dismissal nunc pro tunc. I asked about the statement of evidence at that point. He said he wasn't going to mail anything, that I had no appeal at that point. I rushed down to the clerk's office to ask what's going on. They didn't know. I left the courthouse. I called the Court of Appeals. They indicated that my appeal was on par. They wanted me to drive back to the clerk's office and find out what's going on. When I got back to the clerk's office, I inquired, "What are we going to do?" They said, "We don't know. We're going to mail something. We don't know what it is." Ultimately, on December 21st, they mailed a statement of evidence to me for the record. Of note is the appellee mailed their statement of evidence to this court. Notice me that they mailed it to this court. It goes to the trial court, Your Honors. I had no idea there was a statement of evidence from the appellee in front of the trial court. In fact, on December 18th, I went down expecting them to say they didn't file objections within 15 days. We haven't taken action within 30 days. Your statement of evidence is approved. That's clearly not what happened, Your Honors. Issue 2 is whether the trial judge erred by failing to provide findings of facts and conclusions of law. There is only one finding of fact, and that's that the evidence doesn't preponderate. We'll talk about that. Number 3 is whether the judge erred by denying the petition order protection. So what's on the record, Your Honors? What's uncontroverted here? That's what's at issue. First, as detailed in Petitioner's Exhibit 7, mother's friends have threatened my life. Mrs. Howard decided to pile on to that and call me defamatory and derogatory names. Psychologists call people like this flying monkeys, which refer to people who carry out the work of a narcissist or an abusive person. And it comes from the Wizard of Oz, in which the Wicked Witch of the West and put flying monkeys under her spell. They did the bidding for the Wicked Witch in much of the way as people might work for a narcissist, hence the term being used to describe these people. Again, my life was threatened, Your Honors. It's in Exhibit 7. Mother hacks into my social media accounts. She admits to doing so. It's in the record, Your Honors. The other side says she just hacked in and changed my password. That's not what happened, Your Honors. She apologizes in that text message. She knew what she did was wrong. She was searching for nefarious acts of infidelity, as she always has. On August 14th, Mrs. Howard was supposed to meet me for dinner with the children. She didn't show up. I called her. She was drinking in a restaurant, hadn't gotten her tab yet. She said she'd be there in 10 minutes. She wasn't. I left. Mrs. Howard sounded inebriated on the phone. She admitted days prior to not taking her medications, and she followed me to my house. She jumped through the second-story window at my house. I had changed the locks on my house when she moved out. Interestingly, she knew exactly what window to jump through. It's the one that she came in July and took curtains off of the window. I have 18 windows in my house, Your Honors. She jumped through the exact one that was unlocked. She snatched the kids up. She took them outside and put them in her car. I called the police. Seeing that I had called the police, she took the children out of her car and left. Finally, on the record, Your Honors, is the overwhelming defamatory, derogatory text messages that mother sends me. On page 5 of my statement of evidence, it takes up the entire page, just the explicatives she's used. At trial, I introduced an affidavit where I dropped charges for domestic violence against mother. The judge wouldn't allow it in. There was no objection made. He just stated he wasn't going to hear evidence prior to December of 22. On the bench card, it states there is no statute of limitations. There is no statute of limitations for abuse. Again, mother is under a restraining order per the divorce not to do these things. The Tennessee General Assembly has taken strong, firm stance on the behaviors associated with good cause and an order of protection. 363618 states the official response shall communicate the attitude that violent behavior is not excused, is not tolerated. The other side's brief is filled with excuses like emotions are running high. There is no excuse for the respondent's behavior as outlined in the record. I filed multiple Rule 17 post-trial motions for evidence. Mother continues on her campaign of alienation towards me. My children come to me each week talking about the terrible things that father's doing to mother. It's unacceptable, Your Honors. She threatened to extort my children in December when I wouldn't allow when I wouldn't concede my parenting time for her to go to mother, for the children to go to mother's house. I gave her extra time on 4th of July weekend when her mother was in town. I gave her extra time at Thanksgiving so she could take pictures with her family in South Carolina. It was my parenting time at Christmas, Your Honors. She sent me a text message saying, if you don't let the children come to my house, I'm going to tell them. I'm telling them you won't let them come to my house. How deplorable, Your Honors. How deplorable to involve the children in this, to threaten their emotional well-being, to paint father in a negative light. Issue 4 is whether the judge erred in removing the petitioner's children because Box 2 is not checked. Box 2 has nothing to do with an order of protection, Your Honors. It just states, I'm not listing the children's address if it would cause harm. Mother knows where I live. She came to my house and jumped through the window. I've changed the locks on the house. Box 2 has nothing to do with an order of protection, Your Honors.
Mr. Howard, what is the status of the divorce proceedings?
Yes, sir, Your Honor. It is scheduled for trial on September 19th, Your Honors.
Have any of these issues been raised in that case?
There is currently a contempt motion filed. I think there are 30 issues in that criminal contempt motion. I would call attention, Your Honor, there's a dependency and neglect matter pending as well. The juvenile court has put down an order that says it will not hear motions to modify custody. The circuit court where the divorce at has also said and put down an order, it will not hear motions to modify custody. The court system in Sullivan County with regard to my cases is gridlocked. I cannot go to the juvenile court. I cannot go to the circuit court and ask for a modification.
On this order of protection, was there any testimony or any evidence presented that you were threatened with violence or harm?
Yes, sir, Your Honor. That's in Exhibit 7, my Exhibit 7.
Now, that is contrary to what the statement of evidence that the trial judge presented, though, isn't it?
I assert and I contend that that's not the proper statement of evidence, Your Honors. I contend that Appellee did not file a statement of evidence or objections to mine within 15 days. The court didn't take any action in their 30-day window to do so. I assert that my statement of evidence is the correct statement of evidence, Your Honors. In all those exhibits, I handed Mother a white binder on the stand at trial and asked her to read through the 30-something exhibits of text messages that she sent me. I had highlighted the derogatory, nasty text message names that she called me. She read them. two ways an exhibit can come into evidence. If it's proffered or if it's read onto the record, Your Honors. Those statements are on the record.
Mr. Howard, your time has expired. You have your time for rebuttal. We'll hear from the appellee.
Good morning, Your Honors.
Morning.
I'm Jason Creech of the Washington County Bar, here for the appellee. The appellant says that orders of protection should be the most pro se friendly litigation in Tennessee, and he's correct. It is. The problem is, if you spend enough time in general sessions or circuit or chancery doing domestic work, you quickly realize that because it is so pro se friendly, it is also subject to a lot of abuse. In fact, I would say it's probably one of the most abused statutes in Tennessee jurisprudence. And the reason is what makes it effective in fighting actual domestic violence creates a system where it's over abused because someone can just go to the clerk's office, file any allegations. The clerk takes it to a magistrate or a judge. They get a quick ex parte order in most cases. They're given a quick hearing, and they're often filed in the heat of the moment with people who are in relationships and they're in emotional situations, such as a divorce case like this one. And then they get to the hearing and their facts don't fit the statutory matrix that lays out what's required and what's needed for an order of protection. And it's a classic case of where bad apples spoil the bunch with our order of protection statute. And this is a bad apple case, so to speak. If you look at the file, the order of protection itself is filed August 15th, 2023. And when you read it, it's primarily about this incident between the two parties on August 14th. So what happens is they have this incident August 14th. He runs to the courthouse the next day, files his petition, and we're off to the races. As he notes in his brief and in oral argument, there's a divorce pending, and it's been pending since February of 2023. The parties have exercised 50-50 parenting time, and there's nothing in this record to suggest that either parent's parenting time has been reduced, restricted, or eliminated along the way. There's no evidence of any injunctive reliefs having to be taken out by either party. The August 14th incident itself was regarding a family dinner at Texas Roadhouse that they all planned together. And the appellant has never really answered in his brief or an oral argument the central question I asked in my brief, and that is, how is it that he's so stalked, abused, harassed prior to August 14th that he felt comfortable enough to schedule a dinner with her and have the children with her all together? He has no explanation for that conundrum. And if you look at the exhibits he's actually produced, for example, Exhibit 1, those are texts that actually occur, we know from context, around August 14th, the same time frame. Exhibit 2 is comprised of two sets of texts. There's no date on one set of texts. And then the other set, we know from the date on the thread, is that they occurred between November of 2023 and January 24. Exhibit 3 is a series of text messages. There's no date. We can't tell from the record when they occurred in their marriage, which of course predates even the filing of divorce. Exhibit 4, there's no date. We don't have anything in these text messages that gives a proximate and relevant correlation to the allegations in his petition, because naturally these people are married. Ostensibly they've texted each other every day for years and years and years. And the actual incident on August 14th is not particularly shocking or noteworthy. If you look at the statement of evidence, paragraphs 8, 9, and 16, they establish a pretty clear timeline that, again, they were, as a family, going to have this dinner under difficult circumstances with a divorce pending. Mother's running late. The appellant or father was mad that she was running late, and he left with the children. Mother shows up at the restaurant. She's mad because he took off with the children that she had hoped to spend time with. Father refuses to allow her to talk to them. He refuses to allow them to see their mother. She goes to the marital home, and again, he keeps saying it's his home, his things. They have a divorce. Those answers have not been given yet. So he goes to a marital home. She uses a marital ladder. She talks to their children. He says in his petition and in his materials, he threatened to call the police. They were never called. So this incident was obviously not so dramatic or concerning that the police actually intervened. He said she left willfully. And we know that there were no weapons, no threats of harm, no fear by father or the children. There was no physical injury alleged or proven. There was no damage to personal property. These are all the benchmarks of what we look to in the statute of, is there cause for an order of protection? The remaining proof is basically what I would summarize as divorce drama. The trial court was presented by a situation where the appellant says, I'm being abused. She's saying these nasty, untoward things to me in text messages, and she's saying, I've been abused by him for years. They both claim that they're both harming the children through their actions or inactions, and they both say bad things about each other. The problem is that the appellant had the burden of proof to overcome what is obviously a contentious divorce case. And as I noted in my brief, the trial court is in the position to determine the credibility of these parties. What is more likely than not under preponderance of the evidence standard? The trial court can see the parties live, can ask them questions, see their mannerisms, their verbal and nonverbal cues, and this court is to give great weight to that court's determination. And upon a review of the statement of evidence, you can see this assessment play out in paragraphs 4, 5, and 11. The court notes mother's testimony that the appellant has abused her for years prior to that hearing, that the mother has seen a therapist because of, and I think that word is very important, because of the abusive father. And in paragraph 11, the court finds that there were no actual threats of suicide. And from context, what the trial court is saying is these statements are exasperation statements, where other parts of the record, it's noted that she testified father would push her and push her and push her to the point where she responds in a way that's not great. I can't defend some of the words, but it's a divorce case. And so it's something that I see daily, unfortunately. But what should be noteworthy to this court is the fact that this case started out as an order protection case, and it has become a case about a case instead of a case on the merits. And this is one of the most frustrating parts of this particular case, is that you'll note from the record, father requested an ex parte order of protection. And as this court may know, those are frequently given. In this case, it was not. And immediately, the appellant set upon a path of extreme, over-the-top, vexatious litigation immediately. He filed a motion for reconsider with the trial court on his decision not to award an ex parte with a hearing pending. He immediately launched into this overdrive litigation. You've had several post-trial motions filed with the trial court just to get to the appeal. After the appeal has reached Your Honor's door, we have an order this court entered January 4, dealing with 3 separate motions to consider post-trial facts filed by the appellant. Almost all of those motions and all the things he alleged were not relevant. They're after the fact, and the real only purpose they have is to disparage and run down his wife, the appellee. Constantly negative comments about her, what she's doing, things with the children. There was also a motion he filed to compel the trial court to use his statement of evidence. And then he wanted a motion for a hearing on the statement of evidence. And the court order of January 4 dealt with all those things. And it said the trial court's determination of the record is conclusive, which is the law. Undaunted, January 11, he files a 6th motion, a motion to consider post-judgment facts. Again, it's as if he didn't even hear Your Honors and your prior court order. So again, we have another order from this court, January 24, 2024. Your Honors say the trial court settles the statement of evidence, and we're not going to retrial this case with the Court of Appeals. On January 22nd, the record is filed. Then we have a 7th motion by the appellant, motion to take judicial notice of his statement of evidence. He keeps pounding this drum, pounding this drum. January 31, this court enters an order. The correct statement of evidence is decided by the trial court. Its determination is conclusive. This is about the second or third time I've seen this in the record. So what do we have now? Appellant files an 8th motion to supplement the record, a 9th motion for default judgment, coming back excessively and over to this issue he cannot seem to move past. The court enters its order February 15, 2024. Your Honor said, if it's an issue of supplementation and missing exhibits, we will hear that. You remanded it back to the trial court, instructed the trial court to review, have a hearing. We did. The appellant was there. I was there. We heard proof. We had everything resolved. The trial court sends the record on March 14th with a supplement of, I think there was maybe one extra exhibit. The court noted that, yes, he handed up something, but he didn't enter it as evidence, explained the situation. But all of this was after he filed a 10th motion where he wanted to stay these proceedings so that he could go after the trial judge and file sanctions against him and file a recusal against the trial judge, even though this hearing is already in the rear view. So after March 14th, I had hoped that this long odyssey and ordeal over the record was over and we could just have our day in court and move on. And then I was, of course, discouraged to see in the brief considerable amount of time was spent by the appellant still banging this drum about the record and what proof would have been and should have been and what I was going to say and what I could have presented. He invents proof that's not in the record. He editorializes basically everything in the record. As Your Honor note, even today in oral argument, we're talking about a dependency and neglect he filed. We're talking about all these other things that are not in the record. They're not germane to an actual order of protection. He continues to take pot shots at the appellee inappropriately. In fact, I believe on page 22 of his brief, he goes so far as to talk about the mother having, quote, counseling since 3rd grade, which, again, is I think that speaks to his motives and what he's trying to accomplish here. He's not trying to accomplish justice. He's trying to carry out a vendetta. At page 31, he alleges the trial court and wife's appellee's trial counsel at the time of conspiracy, so that they, quote, conspired, the counsel conspired with trial court and developed a plan in some nefarious attempt to prevent his ability to have an appeal or have his day in court. And in the reply brief I just received, he's still arguing about the record. All that to say, this isn't a case where attorney fees should be awarded to the appellee on appeal. Your Honors know that this is a discretionary question. It's in your sole discretion. And the factors from our case law tell us you need to consider the ability to pay of a party, the success on appeal, whether an appeal was sought in good faith, and other equitable factors. And I think this is a quintessential case where attorney fees should be ordered on appeal. I would note that just this week, I was checking the Court of Appeals record just to make sure there hadn't been any other late filings in this matter. And then I discovered that this appellate has filed 2 other appeals just this week. He filed one yesterday. And he didn't bring it up on his oral argument, but in the case, it's E 2024-00859, he asked this court to hear oral argument on appeal he filed just June 12th. He's already appealed the juvenile court ruling. He's seeking an extraordinary appeal. And I only bring this up to note he listed his income in his own document as $125,000. So he has established his ability to pay in a record in another appeal he filed just this week. He also filed an appeal yesterday under E 2024-00897. So Judge McClarty asks, what's the status of the divorce case? Well, he has filed a recusal motion to try to recuse the current divorce judge, that is the new judge, to replace the last trial court judge he asked to recuse themselves. So I think you've seen, Your Honors will not have seen the last of Mr. Howard when we leave today. And when he goes on, again, to take these pot shots constantly in his motions, when he asks for sanctions, when he disparages the trial court, when he rambles on about things that are not in the record, when we're here talking about flying monkeys and curtains and custody exchanges on what should be just a straight one-issue appeal, this is a quintessential case where attorney fees should be issued, because this is, again, this is not an appeal. This is a plan, intentional, thorough, calculated, and with great energy carried out to wear down and break the appellee. This is his plan, and if you look at the statement of evidence, that's what the court essentially noted, is that he pushes and pushes and pushes until he gets someone to break, and then he records them. That was the essence of how this appellant works. And the trial court could see that, and he knows that. And now what we see is, we're not talking about him and his wife anymore. We're talking about the appellant and the trial court to get to his wife this way. And it's inappropriate and needs to stop, Your Honor. And unless you have any questions, that's my case.
I hear none. Thank you. We'll hear from the appellant rebuttal.
Thank you, Your Honors. If filing was illegal, I'd be in big trouble, Your Honors. That is afforded to me as a right to file an appeal. They tried to strip it of me in court on December 18th. The record just shows that, Your Honors. Unfortunately, the facts that counsel states aren't true. I did call the police. The police came to my house. 2 officers spoke to me. They encouraged me to file an order of protection. I did the next morning. This gentleman's assertion that I never called the police and simply threatened to isn't correct, Your Honors. He talks about me not being afraid of the appellee and inviting her to dinner. That's before she threatened to kill herself twice that day, once in text message, once in video call. I answered that call on speakerphone.
How can that have an effect on violence towards you or the children?
Yes, sir, Your Honor, and if I can grab. The bench card to which this court refers people when they look at order protections, it talks about good cause on here. It talks about a history of violence, respondent's pattern of conduct, respondent's history of stalking, use of drugs, threats of suicide. It's in the bench card, Your Honors. It talks about that being good cause. Mrs. Howard testified at trial that she sometimes threatens to kill herself, but she doesn't mean it. She's done it throughout the marriage, Your Honors. She does it when she's caught not telling the truth, Your Honors. She does it when she did it on August 14th when she was confronted with the fact that she took the children's shoes. She said she didn't do that. I said, you did. You picked them up in your arms and you took them. She said, I'll just kill myself then. She called a couple hours later. That phone call is in the record. It was supplemented on the record. Counsel talks about her receiving therapy because of my actions. Mrs. Howard has been in therapy since 3rd grade. She's been on medications since 3rd grade. Father didn't do this. Father doesn't do this. Father has survived this marriage for 9.5 years. It's vexating having your spouse threaten suicide. It's vexating having her break into your social media accounts and scour them for smoking guns that have cheated on her or done something nefarious. It's vexating, Your Honors. She continues to do it this day. Just last week I was in Texas. She interrogated me. Why are you in Texas? What are you doing in Texas? You have no business being in Texas. I was working, Your Honors. I was sitting right next to my boss. Why does she interrogate me that way, Your Honors? I shouldn't have to answer those questions. Counsel also isn't truthful about the ex parte order. It was issued. I picked those children up for school and kept them during mother's parenting time because the ex parte order was put into place. It's in the record, Your Honors. Counsel said there was no ex parte order issued. That is false. Again, Your Honor, if filing in the courts was illegal, I'd be in big trouble. I'm exercising my rights, Your Honor, those rights that are guaranteed to me by statute and the Constitution. My children were stripped from this petition in court by a judge because I didn't check a box. They have a right to due process, Your Honors. I have a right to present evidence. They state that, well, he didn't present any evidence, so no harm, no foul for the children. I didn't present evidence, Your Honors, because they were stricken from the record, from the petition. Why would I introduce evidence for someone that a judge has simply marked off the petition? I said, Your Honor, you can't mark my children off the petition. I listed them on the front page. It says, list any children that might need protection. He said, I'm marking them off. Drew a line through both their names. The other way to fix this, Your Honor, is to go down and file an order of protection. Just list my children. If they're not on this petition, what prevents me from going down and filing an order of protection for them? Certainly counsel would come here and say, another piece of litigation. How about we just leave them on the petition? How about we just hear the evidence that supports their need for protection? And I see I'm out of time, Your Honors. Thank you.
Mr. Howard, so you understand how you may already know this, but just so you understand how the process goes, we'll take the appeal under advisement. We'll issue a written decision and send you and counsel a copy at the same time.
Thank you, Your Honors.